Welcome back to Good News, Bad News, the Libertarian Christian Roundtable, where we analyze, discuss recent events, and give you the Libertarian Christian perspective on them. This week, we have a major issue that has come to the forefront of American discussion. I have seen it all over my friends' Facebook pages left and right, and it has to do with the Texas abortion ban bill that came to the Supreme Court. So the question
Say that
here,
5 times fast.
Yeah, I know, right? I couldn't even say it the first time. The question is, and this is really going to start with Carrie, and maybe the whole thing will be Carrie talking about this because she's our crack researcher on this. Texas subvert Roe v. Wade with this bill, and I think that's the real question here that some people are asking, and we'll ask further questions about this, as it regards pro-life people like ourselves. So Carrie, what the heck is going on? What happened in Texas, and then what happened at the Supreme Court?
Okay, so first I want to explain what the Texas law is, and you'll have to forgive me. I only went over it today, and so I have notes, but I'm going to read from my notes. So the Texas law is Senate Bill 8. It was passed earlier this year. And what it does is it allows anyone to file civil suit against any doctor, woman, or other person who knowingly performs or intends to perform or induce abortion after 6 weeks. So the 6-week mark is established because that's roughly the time that a heartbeat can be detected. Mm-hmm. And so it allows basically anybody who performs abortion or intends to perform abortion to be sued in civil court. So this isn't criminal.
Who can they be sued by?
Anybody.
Anybody who knows that they've done it.
Yeah.
This presents a very interesting issue, but let's continue.
Let me continue because it gets more interesting. So what this bill allows people to do is it allows you to preempt an actual abortion through injunctive relief. So if you are aware of somebody who is planning to get an abortion, mm-hmm. or planning to do an abortion, you can civilly sue them, and in order to get an injunction, which basically means that they have to not do it. And if they do follow through with the abortion, then there's a civil penalty up to $10,000 per abortion performed or induced. So the defendant or the accused is the one who's on the hook for providing burden of proof. This is backwards from criminal law. So when you press charges criminally, the state is on the hook for burden of proof, and it's the degree of burden is considered in criminal court is considered beyond a reasonable doubt, and then in civil court, it's just preponderance of the evidence. And preponderance of the evidence means that one side has more evidence than the other. So
it's weightier.
Yeah, it's weightier. So basically what this means is the defendant, the person who's accused of having the abortion or intending to have the abortion, has to have a preponderance of evidence that they did not, or that they were not. So, I mean, my advice to women is keep track of your medical records.
That seems like it would be a mess in court anyway.
Yeah, I don't know. I don't know if that's how it typically goes in civil cases. That's one thing that I wasn't able to look up, was whether the burden of proof in civil cases
with the IRS
is typically on the defendant side. If that's the case, then this isn't anything new. So let's see. This would not exclude use of Plan B or even technically medical abortions prior to cardiac activity. So one of the requirements is that a doctor has to prove, before they have an abortion procedure, they have to prove that they have had a medical screening. They've tested to see if there's a cardiac signal.
So a heartbeat test.
A heartbeat. And if there's no heartbeat, they can actually have the abortion. Of course, the problem with this is that most women don't even know that they're pregnant by 6 weeks. So that's sort of the catch here, but it wouldn't exclude Plan B, and I don't know if Texas allows Plan B, but that's another situation. The stakes are lower for civil suits because, if the court decides that you are guilty, that you've done this, then basically you're going to owe $10,000, but you're not going to lose any liberty, like going to jail or anything like that. So the stakes are much lower. Let's see. Oh, the other thing is that the bill expressly forbids any government agents or agencies from initiating these suits. So it's literally enforced only by the citizens. The state cannot enforce it. So the interesting thing is you don't have the situation like I've pointed out that one of the problems with criminalizing it, at least under an authoritarian government, is that you have all of these police powers that are, abuses of power, and we wouldn't want to see that. Well, with this law, you're not going to get that because they're expressly forbidden from initiating any sort of investigation or suit against you. It has to be a private citizen.
So no woman can say or claim that the government has come against her to keep her from keeping her baby, to sue her.
So and I'll explain what the court had to say about this in a second. The only thing that's not clear to me, the language in the bill is not clear to me about how much evidence is required by the claimant or the plaintiff to show that an abortion has actually taken place. That's the only thing that's not clear to me is do you just need a suspicion? Do you just need a vague accusation?
And how in depth are they doing these heartbeat scans to ensure that there is a heartbeat? Are they just kind of waving it over and like, oh, no heartbeat here, 6 feet away?
Yeah, that was the first thing that I was wondering. How can they fake it? Do they have to prove it? Do they have to record the audio? Do they have to?
Yeah, there's some language in here about exactly how they have to test for that.
Procedurally, there seems to be quite a few problems here in terms of how this is run, who can sue whom, and those kinds of things. All for life, all for good things to decrease abortion and have more babies in the world. But it just does seem a little problematic as it pertains to how these actually get enforced and what this could mean for actual legal cases in the future.
Yeah, well, and I want to kind of get a gut check from everybody. What do you think of this kind of law as an approach? I mean, we understand that the reason we're talking about it is because of the Supreme Court making some sort of decision or whatever on it. I don't know the real term there. And so we're talking about it because of that, but it's also because this bill went into effect as of September 1st.
Yeah.
So is this a truly pro-life bill? Is this a step in the right direction? Is it just a hodgepodge of good intentions of hey, we're not going to throw you in jail. We're just going to fine you. Because I've heard people who are against abortion say, well, the woman should be thrown in prison because she killed somebody, or that sort of radical.
Result. I think what's interesting about it, because we have talked from a libertarian perspective, we have talked about how tort law can resolve this issue, and so to a great degree, this does that. I am a little leery about standards of evidence here, and the burden of proof being on the defendant rather than on the plaintiff. But I don't think that we can really know the consequences of that until this is put into action. But sort of the way I had always imagined a tort law situation is that the burden of proof would be on the accuser, and the woman or whoever's being accused would have a presumption of innocence and wouldn't have to defend their innocence. Whereas here they're having to defend their innocence. But the stakes are also lower. So
they're lower, but these are non-trivial stakes though. So I mean, $10,000 is still $10,000 to a lot of people. So that's,
just two stimulus checks.
I just got it right.
I mean, come on.
Here.
Yeah.
let your child tax credit pay for it, or what?
Yeah, right.
Yeah.
I mean, no, but I guess a couple things come to mind for me, and one is on the procedural edge, at least. This is from a very kind of nuts and bolts deal. Undoubtedly, this stuff is going to started getting changed through committee, because having some experience in legislative process in Texas, there is a process that goes through in order to get from point A to point B, and there's a lot of steps that go, so this, depending on where this is in the bill process, depending on what committees have already read through this and have submitted it and whatnot, there's still a number of things that could be changed. And I can only imagine that some of these aspects of there's plenty of things that we obviously haven't had time to go through, but things like who pays for what and so on, and how these suits are filed, those things get elaborated upon down the line. And it'll be interesting to see just how convoluted this ultimately ends up becoming, and how much the spirit of it, decent as it might be in its motivation, will ultimately be subverted by the procedural component of it.
Even getting a bill to the floor is an incredibly difficult piece of work.
Yes.
But like you said, I do appreciate the spirit behind it and the desire to change how the country is. And frankly, if it subverts a little bit of the Supreme Court, all superpower that we kind of have in this country, then I think at least that action of it is good. So I just want to take a moment, thank the sponsors, Hughes, Betancourt, Birdwell, and Buckingham. And Campbell, Crichton, Hall, and Hancock.
The only thing that I would...
Colkhorst, Lucio, Nelson,
you, Matt.
Paxton.
The only thing... He's trying to overpower me again. The only thing that I think absolutely
Shortner,
must be changed...
Springer, Taylor,
changed with certain...
Norman, you can mute him, I think.
Oh, good. The only thing that I do think that needs to be changed with certainty, I mean, I know that there's lots of this that just needs to get worked out, but the one thing that they said was that pregnancy starts at fertilization, and I think that needs to be changed to completion of conception, because there is a 3-day window, and not all eggs that get fertilized actually become conceptus.
Wait, so you were saying that the Texas legislature doesn't actually understand science?
Yeah.
Huh, what do you know? Okay. All right. There you go.
Well, they probably were educated at government schools.
So are we adding a new science term, Texas conceptus?
Texas conceptus. Yeah. Well, you don't have...
Sorry.
Yeah. That process of conception isn't complete until roughly 3 days after fertilization, and that process can fail, in which case you never had a baby to begin with.
That joke was for the KJV onlyists, by the way.
We got it. I'm not a KJV only.
You still got it. I didn't even get it.
Yeah.
I didn't get it.
Yeah.
Texas receptus.
So at any rate, so this...
Oh, that's genius. Good. That's so good. I didn't get it.
Go ahead.
All right. So anyways, that's the law. The idea here is that there's actually no like criminal ban, right? Abortion is still technically legal in Texas. It's just if you find out that somebody's had an abortion, you can civilly sue them. And the complaints that went up before the Supreme Court, which was led off by Whole Woman's Health, one of their complaints was that because these are suits, they are not willing to take the risk of liability, and that will just effectively shut down their clinics. So even though they could technically still perform abortions up to 6 weeks, it's not in their best interest to open themselves up to civil suits. So what they did was they applied for injunctive relief from the Supreme Court, an emergency injunction to just stop the law, at least until they are able to work out details. So an injunctive relief is a writ granted by a court requiring refraining from a particular action, whatever that is. So in both of these cases, you have, the civil law, you can get an injunctive relief. And then they were also in the complaint to the Supreme Court, they were asking for injunctive relief. So the Chief Justice Roberts writes that the Supreme Court cannot say, this is why they denied they denied the hearing. They said that the court cannot say that the applicants, so this is Whole Woman's Health, have met their burden to prevail in an injunction. The requirements for injunctive relief include 1, burden of making a strong showing, 2, that they're likely to succeed on the merits, 3, that they will be irreparably injured absent a stay, 4, that there is a balance of equities that favors them, and 5, the stay is consistent with public interest. So at the very least, we don't actually know what the 5 justices in the majority actually think about this, because those opinions weren't written. And we'll get to that, why that is in a minute. But the dissents were written, and basically what Chief Justice Roberts said in the dissent was, this is the general reason why it was denied. And that was just that they didn't
we don't want to.
Women's Health didn't meet the requirements for them to hear the injunction or the request for injunction. What
that doesn't mean that this can't return to the Supreme Court as a challenge, right?
Yeah.
Like, this is just the injunctive relief decision. This isn't like this bill is at the Supreme Court and the law of the land's going to be determined by blah 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 blah.
Right.
It's kind of like when you have like passing by consent, or to where there's certain types of things in legislatures that pass without actually going through the whole voting process. So they're saying, the burden here is such that in order to get on something that is that easy to go on some, say like a consent approval of a law, it has to be pretty easy. It has to be pretty easy to see that that's going to be okay. Mm-hmm. Likewise, the burden in order to receive this type of injunctive relief is like, it needs to meet this or else it's not going to happen. And if they can't, and probably as long, it has to meet all of them. So if it doesn't meet one, they won't do it.
Yeah.
So that's pretty clear what's going on here, I think.
Yeah, and what Whole Women's Health did in their application was they challenged constitutionality, and Justice Roberts said, but the application also presents complex and novel antecedent procedural questions, namely that this is citizen enforcement through civil courts, on which Whole Women's Health has not carried their burden. So this is why the at least on the surface, why the Supreme Court didn't hear this. And it's because this is a civil law case and not a criminal law case. The state is not the enforcing agent. And that's what's caused them to short circuit, because all of the previous cases on abortion has to do with state enforcement.
Yeah.
Interesting.
So
it feels righteously sneaky.
Yeah. Well, that's kind of the vibe I'm getting. It's like, oh, they strategize this one.
It feels like it, yeah.
So it's not clear. The court said it's not clear whether the Supreme Court can actually intervene on civil matters. And what Chief Justice Roberts said was that this is unusual and unprecedented. And they're not sure that the enforcement of prohibition can actually be delegated to the populace at large. He says, let's see.
Okay.
Yeah. Because that's what they're doing, is they're punting enforcement of this law to citizens, right? It's not the state. And he says here the desired consequence is, he believes the desired consequence is to insulate the state from responsibility for implementing and enforcing the regulatory regime, which actually a lot of this language in the dissenting opinions made me think about all of these mandates that are coming down for businesses to require vaccinations for employees and things.
Interesting.
Because the difference between those two scenarios is that with this Texas law for abortion, they're just opening up the opportunity for civil suit if you want to, right? There's no mandate. Like if you find somebody, if you discover
you don't have
that
a duty to do it, it is a option.
It's only against the law until somebody cares. So.
Right. And so they're questioning in these dissents is whether or not the state can actually punt enforcement to the populace. But that's exactly what they're doing with the vaccine mandates, but they're requiring it. They're not just giving you the option. They're saying you have to do this.
Well, unusual and unprecedented. What would 2020 and 2021 without being at least those two things?
No kidding. So what's the dissenting opinion? I think you're about to read or share some of that, because there's some interesting tidbits about some related topics as well.
Yeah, so Justice Roberts was writing as one of the dissenters. He joined Breyer and Sotomayor and Kagan. And what he said is, well, what Roberts said ultimately is, I would grant preliminary relief to preserve the status quo ante, that means before the law went into effect, so that the courts may consider whether a state can avoid responsibility for its laws in such a manner. Some other things that were stated, please find some of these quotes. So Justice Breyer, one of the things that he stated was, he said, I recognize that Texas's law delegates the state's power to prevent abortions not to one person, not to a few persons, such as the government, but to any person. He says, but I do not see why that fact should make a critical legal difference. That delegation still threatens to invade a constitutional right, and that the coming into effect of that delegation still threatens imminent harm. Normally, where a legal right is invaded, the law provides, quote, a legal remedy by suit or action at law. Marbury, and he references Marbury versus Madison. He closes by saying, the ability to ask the judiciary to protect an individual from the invasion of a constitutional right, an invasion that threatens immediate and serious injury. Excuse me, let me restate that. He says, there may be other not very new procedural bottles that can also adequately hold what is, in essence, very old and very important legal wine. That is, the ability to ask the judiciary to protect an individual from the invasion of a constitutional right, an invasion that threatens immediate and serious injury. I don't see how this cannot apply to vaccine mandates.
Who wrote that?
This was Breyer.
I think he was partially drunk when he wrote that.
He might have been.
Or he had a
What was he
glass of
drinking?
wine on the table.
Yeah. He says this court should not permit the law to take effect without assuring the applicants an opportunity first and fully to make these and other arguments supporting the request for an injunction. Let's see. Sotomayor said the court's order is stunning, but apparently not brave.
Very good. Didn't have enough pink hair.
No, there you go. Yeah. She says, last night the court silently acquiesced in a state's enactment of a law that flouts nearly 50 years of federal precedents. The Texas legislature was
We wouldn't want to flout.
Yeah. The Texas legislature was well aware of this binding precedent. So this is the precedent about, from Roe v. Wade and Planned Parenthood versus Casey. To circumvent it, meaning the court's precedent, the legislature took the extraordinary step of enlisting private citizens to do what the state could not. In effect, the Texas legislature has deputized the state's citizens as bounty hunters, offering them cash prizes for civilly prosecuting their neighbors' medical procedures.
Wow.
Yeah.
Wait, how do they get the cash prize, though? That seems...
I guess that's the $10,000... That's the $10,000 civil penalty.
Can we get a tally of every time Sotomayor was actually happy on the Supreme Court?
Oh my goodness.
let's see. She goes on to say, by prohibiting state officers from enforcing the act directly and relying instead on citizen bounty hunters, the legislature sought to make it more complicated for federal courts to enjoin the act on a statewide basis. She says, taken together, the act is a breathtaking act of defiance of the Constitution, of this court's precedents, and of the rights of women seeking abortions throughout Texas.
Well, 2 out of 3 of those seem like not a big deal. But
because 2 out of 3 ain't bad. Well, again, I would like to congratulate Burroughs, Click, Kane, Leach, Allison, Anderson, Ashby, Bales, and Bell, and Beardman, and Bonin, Buckley.
You guys have to hear this. She says, today the court finally tells the nation that it declined to act because, in short, the state's gambit worked. It cannot be the case that a state can evade federal judicial scrutiny by outsourcing the enforcement of unconstitutional laws to its citizenry. Instead, the court has rewarded the state's effort to delay federal review of a plainly unconstitutional statute enacted in disregard of the court's precedents through procedural entanglements of the state's own creation. And then Kagan says a lot of the same things that Sotomayor does as well. But the thing that she brings up is the court's shadow docket. She says today's ruling illustrates
that
just
sounds
how
conspiratorial.
I know.
Just this idea, like
shadow docket.
It's like shadow money, shadow docket.
It's the deep state. Let's put on our.
State.
She's wearing the tinfoil hat with us.
Yeah. Please hold on while I go get my tinfoil.
She says today's ruling illustrates just how far the court's shadow docket decisions may depart from the usual principles of appellate process. That a challenge to an obviously unconstitutional abortion regulation backed by a wholly unprecedented enforcement scheme is unlikely to prevail. In all these ways, the majority's decision is emblematic of too much of the court's shadow docket decision making, which every day becomes more unreasoned, inconsistent, and impossible to defend. And I had to go look up what the shadow docket was, and there's actually been some congressional hearings on this, and so it's actually not conspiratorial. It's a real thing. But some of the things that are on this shadow docket for the Supreme Court are abortion, and also all of these COVID restrictions and vaccine mandates and things like that, religious liberty during a pandemic. There are some other things. I think immigration is on there, some other topics. But basically, what I understand what the shadow docket does is it allows the Supreme Court to make decisions behind closed doors without us knowing what those decisions were or really why they were made. So in this case, we don't have any of the majority's opinions as to why they decided what they did. So we don't even though pro-lifers might see this as a win, we don't know why they made this decision, and so it might not be the win that they think it is. For all we know, that there's a challenge to bodily autonomy and agency when it comes to making medical decisions. There could be that. So at any rate, that was the other thing that was brought up, was the shadow docket. So
there's a lot that could be discussed here. One that comes to mind, and I don't want to be the spoil sport per se. I mean, as we've said, we're for life affirming. We've always said we're for life affirming options and for things that take place that will reduce abortions realistically. But I'm not convinced just off the top that this is immediately like a priori obviously good bill. And I'm kind of curious your perspective on that, Carrie, because it doesn't seem like this instantaneously just screams, "Oh, this is the life affirming way that one goes about doing this."
Yeah, so there are a couple of things. And number one, I wanted to add to this that one of the reasons, so this bill can actually come back before the Supreme Court. One of the reasons why they didn't hear this is because there's been no actual evidence of enforcement right?
Yeah.
Obviously, it started today, but they don't know if the citizenry is actually going to enforce it. And so if it gets enforced, then it can go back before the Supreme Court and they can look at it procedurally and all that.
Yeah.
As far as
and can I stop you there too? Because even with citizen enforcement per se, there's, if I'm to understand correctly, so tell me if I'm getting this right. So if a civil suit were to occur, you know, and somebody files suit against, you know, John files against Jane or whatever, and then two different fines can occur. $10,000 on the woman who is pregnant and wants to get the abortion, and $10,000 on the institution or individual who is performing. Is that, do I have that right, or is it just one?
So it's, they can sue the doctor, and they can sue the woman, they can sue anybody who helped. So if you paid for it, so that's three people.
That's unclear. I don't know if that's wholly may end up being the case. It would be like suing, you know, the Planned Parenthood facility, right, or something to that effect. But here's where I'm going with this, though. It seems like that, you know, even with this idea of trying to appeal for injunctive relief, it's not, you know, that they're not irreparably harmed. The Planned Parenthood wouldn't be irreparably harmed because you know what they can do? Raise their price. Like that. So this becomes, you know, the price of doing business per se. And that's not something that the government tends to, like. I mean, yes, they sometimes execute price controls, but this is not something they typically will get involved in. So I don't fully understand, like, that would be the irreparably harmed thing is probably what I would bank on as why the Supreme Court did not issue the injunctive relief off the top, because it's totally not clear.
So I would think that if a case would be successfully, successfully affirmed at the Supreme Court, it would have to be an individual making the complaint rather than, you know, the corporation. And, you know, it's not, I mean, aside from the fact that burden of proof is, you know, to defend your innocence, and I have problems with that. And the fact that we don't know how much of an accusation it takes, like what degree of evidence does a plaintiff need to have in order to open up a case, or are we going to see a bunch of frivolous lawsuits? So that's a concern.
Real quick for the roundtable, can we get just a quick consensus on how we feel about this bill? Yay or nay, or in the middle? 3, 2, 1, go.
I think this should have blowback.
I think that there will probably be a lot of unintended consequences.
Kudos for the not shenanigans. What's the word you said? The
shadow docket.
Not the shadow docket.
The short circuiting.
Yeah, the little bit of like, okay, well, we're gonna do this at the civil level. So
subversion.
It's gonna be subversion. Yeah, so that the Supreme Court's gonna take longer. It's gonna take a while to play itself out a bit and to see how this is gonna go. It could be a nothing.
Yeah.
It probably isn't. There's probably gonna be cases, and we're gonna see this again. But it could be a nothing. Yeah.
You know, I think you're probably going to run into situations where the other thing that I'm not clear on is they bring in insurance companies in the language of the bill. So I imagine that insurance companies will stop offering to pay for abortion services. The interesting thing about this, though, Norm, is that the economic study that they've done on abortion services, they've found that, you know, trying to restrict the supply side doesn't actually change any of the numbers of abortions.
Yeah.
Whoa, Bob.
But
Matthew, hold on.
Hang on. Let me finish my thought, Matthew.
Oh, go ahead.
But on the demand side, they can affect numbers of abortions. They can make them go down by making the price go up, by making it more expensive to actually get the abortion.
You mean like a vice tax?
No. Just
I was comparing.
Oh,
like saying that was what was happening.
Yeah.
No, what they found was that when you don't have insurance paying for abortions, or you don't have, discounts for out of pocket, or you don't have people, offering to pay or whatever, then women will choose not to have abortions because they're too expensive. And so, even if you have a situation where Planned Parenthood just passes off the cost to their customers, they're still going to have a reduction in demand.
Sure.
I think that the problem that they'll run into, though, is that a lot of these women who seek abortions, because it's not just going to Planned Parenthood to obtain a procedure, it's also inducing an abortion. So if you're found, say, taking a concoction of herbs that can induce abortion, it can basically induce labor before viability, then you can still be charged or sued under this law for inducing, and you haven't gone to an abortion provider or a doctor to get those procedures done. So I can imagine that.
Look, Judge, I have the herbs in her tea right here. Like, how in the world do you? Yeah, man.
Yeah, I don't know. I can imagine women in poverty getting caught up in this. I kind of wonder how they would actually, enforce the penalty, the $10,000 penalty. They did say up to $10,000, so I don't know, if that's, how they would figure that out. There's a lot of unknowns. And I think ultimately the big thing for me is that if we're going to ban abortion, it should be criminal because it's murder. But that means that the woman, who's being accused has she has all of those rights. She has the rights of the accused. So she has presumption of innocence. She has the right to bodily integrity and against unreasonable searches and seizures and things like that. She has those protections.
Self-incrimination, whatnot.
Yeah. When you have, imagine a poor woman who hasn't even had an abortion and somebody accuses her, but she didn't know ahead of time that she needs to be keeping all of her medical records and whatnot. If she can't prove her innocence, then she could be liable for civil penalties because the burden of proof is on her. So I think that part is problematic. And I do kind of think, though, that this whole thing should really challenge this idea that the court's precedent reigns supreme. Essentially what a lot of these dissenting justices are saying is, we set precedent. We should be allowed to hear this case and make the determination about how this works. And they're short-circuiting because they don't know how this works because they're not being allowed to hear the case. But I think as far as we're concerned, that should be raising the red flag of who actually governs in this country. Is it really we the people, or is it the Supreme Court ruling on their precedent?
And there's issues, and then there are meta issues.
Yeah.
And we've all said that
issue?
Roe.
Sorry,
we've all said that Roe is a bad case, and overall for law in general. So this kind of just continues the whole ball of wax. So
yeah, what I would really like to see, quite honestly, I would like to see some lawyer out there really challenge. I mentioned before that I think that these dissenting comments touch on the issue of vaccine mandates. What I would love to see is some lawyer out there challenge these vaccine mandates on the basis of the precedent set by Roe v. Wade and Planned Parenthood versus Casey, which is that a woman has a right to bodily autonomy, agency, and that her medical decisions are left between her and her doctor. And then argue.
Then we'll see who's
And basically that puts the court in a really bad, a bad position, because they will either have to lose on abortion or they'll have to lose on vaccine mandates. But if they win on abortion, then you just, for men, you claim equal protection under the law, and then extend that to children as well. And eventually, I think you would have to actually amend the 14th Amendment. The 14th Amendment is what gives a woman, allegedly gives a woman the right to abort. I think we would have to change the 14th Amendment to say, to take out the word born, in order for it to apply to fetuses. But I think that I think the vaccine mandates should be challenged on the basis of Roe v. Wade and Planned Parenthood versus Casey.
That's very interesting.
Federally, that's
we should have
really
led
hard
with
to
that,
do.
Carrie.
Yeah, way to bury the lead.
Yeah,
Seriously.
bury the lead. Yeah.
Man, oh man.
All right.
Well, it is really interesting to consider where this could go, and I think we have a long ways to go before we even see if this doesn't even get out of the Texas legislature. I mean, it might not get out of the House, and if it doesn't get out of the House,
Well, it's in the Senate right now.
okay. Well, if it's in the it still has, just like it is in national politics and in national.
No, it's not in the
legislative
Senate.
It's
Sorry.
not in the Senate. I think it's
No,
already.
the governor signed it.
Yeah, it's already
Yeah.
signed. It's enacted.
Oh,
Actually, signed today.
Yeah.
wow. Okay.
Yeah.
9-1.
So it's already enacted. So I
Today's
think
not
the thing that
9-2.
we're waiting for is whether citizens are actually going to enforce, whether they're actually going to carry out lawsuits.
Wow. Well,
Fascinating.
thanks, Kiri, Darby, Dean, Elsie, Franken, Frulo, and Gates, Goldman.
Well,
Arliss,
Carrie, thanks for
Harris,
bearing
Hefner.
the burden of this
Holland.
entire episode and fielding our questions and all of that.
Yeah.
We appreciate your enthusiasm for communicating the truth about these issues. You definitely are on top of things, and so, Matthew.
And there's a whole chapter
Just so you
about
know,
abortion
we're having a
in
conversation
the recent book that we put out called
That's
Faith Seeking
right.
Freedom,
Faith-seeking
and
freedom.
a recent podcast that's even been released on the topic as well,
Yeah.
where we were talking about this.
Yeah.
Which is
And-
not for resale.
Oh,
No,
that's
no, Matt, wrong copy.
Not-
that's the secret
not-
version.
That's the secret
Jeez.
That's-
pre-release version.
Ah.
That's the shadow docket.
Yeah.
So
Don't give away our
we're
secrets.
gonna wrap this up, and we are going to encourage you to visit libertarianchristians.com. You listen to the Libertarian Christian podcast, and we will see you next time.
Lozano, Metcalf, Middleton,
Major issue.
Murphy.